Does the spacing between the words of a trademark affect trademark rights? A viewer asked me that question. She wants to know. I'm Angela Langlotz, trademark and copyright attorney, and I go live here on weekdays to discuss trademarks and copyrights. I'm going to spend the next 4 minutes answering her question. So her question was, if I trademark a business name and fail to put a space between the words, for example, HappyDay, one word, versus Happy Space Day, will both be registered? And the answer is no. The junior mark in that case, assuming the goods were related, would not register. Why? Well, when we evaluate whether or not trademarks are confusingly similar, and that is the standard, when we evaluate the similarity of the marks, one of the things that we look at is the overall commercial impression that the mark makes on the consumer. And commercial impression incorporates a lot of factors, but one of those factors is the way the mark sounds. So when we say things like Happy Day, we don't know whether or not there is a space between the words happy and day. It just sounds exactly the same as Happy Space Day because we don't walk around putting spaces in between the words of our speech. That would be a little bit weird. We would half space, two space, go space, around space. I think you see what I'm saying. So we would pronounce Happy Day, one word, the exact same way that we would pronounce Happy Day, two words. So the commercial impression, the auditory commercial impression that the consumer would get would be exactly the same for those two marks. In addition, the consumer is likely unable to distinguish at first glance whether or not the words actually have a space at all. It would depend upon how the words were presented to the consumer as well. So in this case, assuming the goods are related and assuming a mark like Happy Day, this trademark application, so we have a junior mark that's being applied for and a senior mark that's already registered, right? So the junior mark, if the goods were related, and you can look at my other videos where I talk about this related goods issue because it's an important and often misunderstood issue. If the goods are related, and that means different things under trademark law, and so if the goods are related and the marks convey a similar commercial impression, then the application for the junior mark will be denied because it would be confusingly similar to a mark already on the record. So I'm going to tag the person who asked this question. What was her name? Alyssa Burton. I'm going to tag her in this video so she knows I answered her question. If you have trademark questions, please drop them in the comments below. I will answer them in a future live video. You can find me online at TrademarkDoctor.net. On YouTube, just go search Trademark Doctor and you'll find hundreds of videos that I've produced live there. And you can also find me on Facebook at facebook.com/TrademarkDoctor.